The European Union Artificial Intelligence Act came into force in August of 2024. It governs the use of AI systems across a broad range of sectors and is intended to ensure that AI systems are safe, respect fundamental rights, and align with EU values such as democracy, human dignity, and non-discrimination. The EU AI Act aims to minimise the risks associated with AI, especially in critical sectors such as healthcare, education, employment, and public services. Moreover, the Act seeks to establish clear rules for the classification of AI systems, distinguishing between low-risk, medium-risk, and high-risk applications. High-risk AI systems, in particular, are subject to strict regulatory requirements to mitigate potential harms. Another important objective is to promote transparency in AI by ensuring that users are informed when interacting with AI systems and that decisions made by AI are explainable. The EU AI Act categorises AI systems by the level or type of risk they pose and imposes specific requirements for each risk level. The figure to the right provides an overview of the various risk levels.
Systems with unacceptable risk are categorically prohibited. These are systems that manipulate human behavior or that classify people based on their behavior, socioeconomic status, or personal characteristics, known as social scoring systems. Also prohibited is the untargeted scraping of facial images off the internet for purposes of building face recognition databases. Emotion recognition in the workplace or educational institutions is prohibited, except when used for medical or safety reasons. Also prohibited is the use of real-time biometric identification systems in public spaces, such as facial recognition, iris scanners, or others. Biometric categorization to infer race, sexual orientation, political opinions, or religious beliefs is also prohibited as posing an unacceptable risk.
Systems with high risks are those that could be expected to pose significant risks to health, safety, or the fundamental rights of a person. The EU AI Act imposes a registration requirement for AI systems operating in specific sectors that are deemed to present such a high risk. These include operation of critical infrastructure, for example, water or electricity supply, air traffic control, education and vocational training, employment, worker management, and access to self-employment. The latter would capture the so-called gig economy companies like Uber, access to essential private and public services and benefits, law enforcement, migration, asylum and border control, assistance in legal interpretation and application of the law. Additionally, AI systems that are incorporated into products governed by EU product safety regulations, toys, cars, medical devices, etc., are also considered high risk, but do not have a registration requirement. For AI systems classified as high risk, the AI Act imposes several strict regulatory obligations: risk management and mitigation, data governance and quality requirements, logging and record keeping, transparency and information disclosure, human oversight.
Systems that pose a transparency risk are those that could be used to impersonate or deceive users or third parties. Typical examples are chatbots, deep-fake AI systems, and AI-generated content. The EU AI Act imposes information and transparency obligations on such systems. That is, users must be informed when they are interacting with an AI system, and the output of such systems must be marked and disclosed as AI-generated. Systems that pose minimal risk are the remaining systems that do not fall in the other three categories. There are no regulations for their development or use, nor are there registration requirements. Organizations developing or deploying high-risk AI systems will need to undergo compliance assessments conducted by either the organizations themselves or third-party bodies, depending on the type of AI system involved. Developers will also need to register certain high-risk AI systems in a public EU database, allowing for transparency and public oversight. Non-compliance with the AI Act can lead to significant penalties, including fines. For the most serious infringements, such as deploying prohibited AI systems, the AI Act allows for fines of up to 6% of a company's global annual turnover. Lesser violations, such as failure to comply with transparency requirements, can result in fines of up to 4% of global turnover. In conclusion, the EU AI Act is the first legislation that recognizes the risks posed by AI and machine learning systems, and is a first attempt to regulate these systems to reduce or prevent potential harms.